All right, I think we're going to get going. Welcome. I want to first of all congratulate, I'm not sure who it was, but whoever came up with the title for this session and the delightful wordplay of making census of the population and redistricting. But this is anything but a light subject. This is our very democracy that is at stake here. And today you'll have a really stellar panel to explore the many issues arising from the upcoming census, the last census, and the several redistricting cases that the Supreme Court will rule on Monday in the coming weeks. I'm told I should make some administrative announcements. Please mute your cell phones. If you wish to tweet, the official hashtag is ACS 2018. If you want CLE, you have to get your badge scanned. If you leave early and you're honest, you should have your badge scanned again. We're going to have some questions and answers at the end, and it's such a rich array of topics, I'm sure you'll have a lot of thoughts, so we'll leave ample time for that. Let me introduce the panel before we jump in, and I'm going to do it in cursory fashion. They all have extended and impressive resumes. I'm sure they're available in the materials. Directly to my left is Terry Ann Lowenthal, who is a nationally recognized expert, consultant, and speaker on U.S. Census and policy issues. For 14 years as a congressional aide in both the House and the Senate, she focused on these issues and knows them as well as anyone. Next to her is Guy Charles, a law professor at Duke, specializing in election law, race, constitutional law, and civil procedure. He clerked for the great Damon Keith of the Sixth Circuit and is at work with a co-author on a book entitled The American Promise, Rethinking Voting Rights Law and Policy for a Divided America, which sounds quite timely. Next in line is Kate Mcknight, who practices commercial litigation and, for our purposes, notably election law at the Baker and Hostetler firm. She's been deeply involved in major redistricting litigations. Next down the line is Arturo Vargas, who is the executive director of the National Association of Latino Elected and Appointed Officials, which is as the name suggests, a national membership organization of Latino policymakers and supporters. And at the end of the table is Wendy Weiser, who's the director of democracy programs at the Brennan Center for Justice at NYU's Law School, where she focuses on voting rights, money in politics, redistricting, representation, fair courts, and government reform. So you'll see we have an embarrassment of riches in terms of both speakers and topics. And I've urged the speakers not to give you a set of canned lectures, but to have a discussion about these pressing issues. And I think maybe I'm going to ask Arturo to set the table a little bit and tell us about the importance of the upcoming census and how it may be affected, nay, warped by a question about citizenship.
Yes. First of all, good morning, and thank you for the opportunity to be here. I do have to say that my husband, who's a federal judge in Los Angeles, is sitting in his chambers right now wondering why I'm on a panel at the ACS, and he is not. Not being the lawyer in the relationship. I first learned about the request of the Department of Justice to add a question on citizenship on December 29th. And I learned it from a reporter. And my reaction then was, this is the best way to sabotage the 2020 census. And what we have seen since is exactly that. We're seeing one of this country's most fundamental elements of our democracy enshrined in the Constitution completely being undermined and sabotaged. The citizen question being Exhibit A. But because it is so important and we have focused now so much attention on it, I also want to remind us there are many other elements of what's happening in the implementation now of the 2020 census that will be equally as damaging to the ability of the Census Bureau to fulfill its mission. There are changes being mandated upon the Census Bureau to the point that, rest assured, the operation that the Census Bureau will carry out in 2020 is not the census that the Bureau has been planning for the past 10 years. There are fundamental differences to the operation and the questionnaire of how the Census Bureau is being forced to make last-minute changes that are completely untested. And that goes to the issue of the citizenship question. Yes, it is on the ACS, the American Community Survey, and the argument has been made, oh, we're asking it already on the survey. A survey of 3.5 million households is not a decennial enumeration of 100% of the nation's households. They are fundamentally different operations. The Census Bureau spends years researching every single thing that is included on the questionnaire, down to the actual wording. Do we use sex or gender? What is this person background or category? And what is the order by which we ask these questions, all to elicit the best responses? And now the Bureau has been forced to ask what is an incendiary question, asking everybody, are you a citizen, yes or no, in this current political environment? And in his wisdom, the Secretary of Commerce has decided himself where that question should be placed, with absolutely no empirical evidence. By making that question the last one on the questionnaire, it would have any effect on increasing response rates. We know already by focus groups that we're holding around the country, surveys we're doing of immigrants, mixed status families, that there is great fear by Latinos, Asians, of their own federal government, citizens fearful of their own federal government, to the point that I think it's going to be this country's most serious challenge to ensure that we can convince them that come 2020, they should be completely assured and confident that they should fill out a form sent to them by the federal government and list all personal information that is asked of them and their family members. This census is in serious risk.
So, Arturo, if I understand you correctly, you think the Trump administration acted rashly and for political purposes?
You know, at some point you just can't give them the benefit of the doubt anymore. And in this particular case, when the Trump-Pence re-election campaign issued an email campaign fundraising message saying, support President Trump, he's trying to add a citizenship question to the 2020 census, it was clear that there were political and partisan motivations behind this.
Terry Ann, you've worked in this area for a long time, and I'd like you to give us your thoughts about the importance of the census, what the census mean to do, and perhaps respond to this question, which is I take all of Arturo's points, and yet in the Evenwell litigation, which was about who gets counted in drawing districts, there was a lot of talk that you can't confine it to eligible voters because we don't have information. We don't have adequate statistics. We don't have the data on who's a citizen and who's not, and it would be good to have that data. And now when the Trump administration says, okay, let's go get that data, people seem to switch sides a little bit.
Well, I think that's correct. I mean, there seems to be any number of reasons that this administration made adding a citizenship question and collecting data on citizenship a priority for this census, as Arturo indicated. You know, I just came from a hearing of the House Judiciary Committee Subcommittee on the Constitution, which was scheduled at the last minute, looking at proposals to add a citizen, not just a citizenship question to this census, but a question on legal status in order to determine the number of undocumented residents in the country. That has never been asked on a census. It seems like something that is designed to doom, as Arturo suggested, to doom the census. And I think that in terms of participation and in terms of accuracy, so that, in fact, the data that eventually gets used for redistricting maybe does not reflect the full population by default you know, even if they can't specifically constitutionally exclude a subset of the population from the state population totals used for apportionment. So I think that's a little bit of what, I think that's not a little bit, I think that's behind a lot of these proposals. I mean, I would just conclude by, you know, sort of trying to say, well, what's, if this census is a bad census. Congressman Nadler was at the hearing this morning, and that's what he said. He said 2020 could be a bad census, and we might have to redo it 2 or 3 years after first census. And my eyes went, oh my gosh. But I guess the question is, what is a failed census? And I think that if the public and public officials lose faith in the integrity of the process of taking the census, which Arturo discussed a little, but also in the accuracy of the results if the census starts and it becomes clear that operations and participation are starting to really go south, then I think we are left with a failed census, and then Congress could begin to question whether the results are sufficiently fair and accurate to use as the basis for congressional apportionment. I mean, I'll just conclude, because it's the Constitution Society. This nation has failed to reapportion the House of Representatives after a census only once in its history. Coincidentally, for those of you who remember, you know, learning this in school, coincidentally, 100 years ago, after the 1920 census. And that's because that was the first census that showed that a largely rural nation had now become a largely urban nation. And so the members of Congress, who were still primarily representing rural areas, refused to accept the apportionment. And Congress was not reapportioned for 10 years. So that is clearly a constitutional crisis. I think that could, I'm not saying it will, I think it could happen this time, and I'll just finish by noting that there's some parallels, because I think the concern in some political quarters about the implications of substantial and rapid demographic shifts right now, right, in terms of what this population looks like, the consequences of that for the distribution of political representation could bring us to a similar place from where we were in 1920 in January of 2021.
Oh, what a sobering
That's
thought.
a constitutional issue.
As though we need another constitutional crisis.
A good law school paper, though, for those of you who are still in school.
So let's shift gears just slightly and into an area of very pressing concern for me and my colleagues who cover the Supreme Court. We're waiting on a pair of partisan gerrymandering cases, one from Wisconsin, one from Maryland. Guy, can you tell us, set the table on that?
Sure. Yeah, so let's talk about that. And both of those cases, I think, are relevant to some of the issues that we're talking about with respect to the census. But I want to begin by just framing two particular sets of questions. So for me, these cases raise questions about how far, obviously, can political leaders go to hold on to political power, right? Sort of like there are two ways of thinking about these sets of problems. One is we could trust that our political leaders will allow us to make decisions about their terms in office and whether they're doing a good enough job, or we can allow them to decide how long they're going to hold on to political power and how much to entrench themselves as political leaders. And the gerrymandering cases raise precisely these sets of questions. One case, as you mentioned, Adam, out of Wisconsin, Gale versus Whitford, challenge to a state redistricting plan. The Republicans controlled the state legislature for the first time in almost half a century, and they decided to entrench themselves as best as possible and hold on to power as long as they can. So they created a state legislative plan in which they received about half the vote as the Democrats did, but came out with 2/3 of the seats from the state legislature. The second case comes from Maryland, as you mentioned, Benesek versus Larimore, and that's a challenge to a congressional redistricting plan. There, the Democrats controlled the redistricting process, and the Republicans are complaining that a congressional district was gerrymandered to favor the Democrats as opposed to the Republicans. So we have two questions. The first is already posed, which is, will the court view the attempt by politicians to entrench themselves as long as they possibly can against the choices and preferences of the electorate as a legitimate exercise of politics, or does that raise significant constitutional questions, whether it's under, for example, the First Amendment or under the 14th Amendment, with remedies available to address those? Or will the court simply take a pass here? If I made a prediction, you should not believe. I have no idea what's going to happen, so I'm not going to even venture to make a prediction. As we all know, we are at the whims of the Republic of Justice Kennedy, especially in these areas. And from the last gerrymandering case, we had 4 justices who thought that these issues were not justiciable, 4 justices who thought that they were. Both sides claimed that Justice Kennedy was on their side. Justice Kennedy had a chance to speak for himself, and if you remember reading what he said, it's also unclear which side that he favors. So hopefully the court will provide more clarity on these sets of cases, and we will know if this fundamental question about democracy, democratic authority, democratic accountability will be resolved in favor of greater democracy, or if we're going to continually live in a partisan world in which partisans will rig the rules of the game, whether it's the census, whether it's voter IDs, whether it's gerrymandering, will decide that the rules of the game ought to be rigged to favor their side as against the preferences of the electorate.
I'm going to ask the panel more generally, excuse me, if anyone's willing to be a little bolder than Guy and give us some ideas about how these cases might come out. And in particular, maybe let me ask, it came as a surprise to a lot of us after the Wisconsin case was argued that the court then took the Maryland case. Didn't know what to make of it. It looked like in the Wisconsin case that Kennedy was open to the idea that something needed to be done here. But then they take the Maryland case, and at the Maryland case, it looked like the court had no idea what it wanted to do and where it was going. So I wonder if anybody has ideas in a general sense about a likely outcome, a possible outcome, or more specifically, why they took a second case having chewed over a similar one to begin with.
You're looking at me. I don't know that I have a solid prediction. I am an optimist. I will add that there's actually a third case I just sort of want to throw in there that was not argued, but coming out were a pair of cases out of North Carolina where the court below found a partisan gerrymander. It's fully briefed before the court. The court hasn't taken it up or decided not to take it up. It's holding it. So there's really kind of 3 separate patterns in play. In North Carolina was a case that came out of, there was an illegal racial gerrymander that was sent back down, and the legislature replaced it with a partisan gerrymander expressly, eliminated race data, and said we want an outcome that will guarantee the Republican a 10-3 seat advantage, and that is what is up before the court too. So it's really 3. An optimistic take of why it took the Maryland case is if it was going to find a claim for partisan gerrymandering and find that and throw out these maps, that it would want to have partisan balance in doing so. And so it has a case with where Republicans gerrymandered in one case and where Democrats gerrymandered in another case, and that would be an optimistic sign, and a sign that one of the questions that Chief Justice Roberts raised, it would address a question he was concerned about, or professed that he was concerned about what it would look like to the public of the partisan preferences of the court if it got involved and struck down cases in this way. So that's an optimistic take. Another possible take is that The Maryland case very squarely and specifically addressed just the First Amendment and raised a First Amendment claim, which is something that Justice Kennedy has been interested in, and so that he was sort of struggling with figuring out a standard that was to his liking. That might be a slightly less optimistic take, that he didn't yet find something that he liked. Another possible reason why there's two cases is one of the Wisconsin case looks at the harm of gerrymandering as a statewide harm. It says what was wrong here is that the Republicans tried to maximize their advantage, lock in this advantage over time on a statewide level, and that's what drove the redistricting process, and it locked out voters in so doing. The Maryland case looks at one particular district, and it says the harm there was injuring the voters for choosing to put them in or out of that district because of their political preferences and to otherwise undermine their political power. And that distinction maps onto or raises questions because in the racial gerrymandering context, where there already is a well-established claim, and in both cases the Supreme Court has said it's improper to gerrymander. Just in the partisan context, the court has never found a standard that it likes that it will allow claims to go forward. The racial gerrymandering context looks at claims on a district-specific basis. So so it was struggling with whether or not it wants to look statewide or district-wide. Is that an optimistic or a pessimistic take? I don't know. I am an optimist that these cases that there were more than one case heard, and that's a good sign. Also, a lot of stars have aligned this year. I mean, this has really been a remarkable year for the legal fight against partisan gerrymandering. Before this year, there were no courts that had ever found a state map to be an illegal partisan gerrymanderer. We've had multiple courts do so. And this isn't just the federal court cases we have just heard about. There was a Pennsylvania Supreme Court case that did that as well. There's been a real dramatic consensus built, especially on the progressive side, but not only on the progressive side, in the legal community, in the social science community, even among some Republicans as well, that not only that gerrymandering is wrong, it needs to be curbed, it's gotten so bad and out of control that we need to have some way of reining it in and putting some limits on it, but that there's an actual way to do it, that there are actually widely accepted standards for measuring it. There are more than one way to do it, but you can actually recognize it, and so that's been a dramatic step forward as well. So, and the problem's gotten so bad that it's hard to say that the status quo can just go forward. I think if the court does not recognize a claim here, it's not going to be more of the same. It's going to get worse. It's going to continue to get worse. It's worse this decade than it's ever been before. The gerrymanders have been more extreme and also more durable. They've lasted throughout, the skew has lasted throughout the whole decade. And that's in part because of new technologies, data technologies, technologies for precisely drawing your maps and predicting outcomes, but also there's no longer any deterrent to being really extreme in the gerrymandering. As more and more people get away with it, as the risk of judicial intervention goes down, it will continue even more. So those are reasons I'm optimistic.
She still has not made a prediction.
But it's so bad, they're going to do something about it.
You want to jump in, Kate?
Sure. And I might be the one to throw a little cold water on some of the things that have been said. First, maybe to start where Wendy left off, as far as political gerrymandering goes, and just so you know, I'm a lawyer, I'm a litigator, I've worked on cases on redistricting in courts, and what I am seeing is a number of cases being brought about political issues that should be resolved in the political process by a legislator, by a legislature, by the election process, by citizens' movements. Though that may be slower, in my opinion, it would be much more efficient and clear, not only to lawyers, we're always looking for some amount of clarity, but to the legislators and other map drawers out there who are going to be tasked with redrawing these maps in just a few years. We have the census coming up. These maps will need to be redrawn in 2021, so it's just around the corner. And as I think you've already heard here, there is quite a bit of uncertainty in the realm of redistricting law. Now, we've talked a lot about partisan redistricting cases here today. I know Guy can also talk about some of the racial redistricting cases I've worked on, he's written about. But in both areas, there is a lack of clarity that is going to be very difficult for legislators and map drawers to deal with when the time comes in a few years. And let me say a few more points just to address what Wendy said and what Guy also said. And I've said this before, and people have come after me, and I'll say it here again. There is actually only so much you can do with redistricting. What I mean by that is, when you are redistricting, you must draw the map, the district, so that it complies with one person, one vote. That is everyone's primary responsibility in redrawing a map. That's the #1 focus. Now, courts have come in and have identified a number of other restrictions. It's not just courts. We also have federal law. We have the Voting Rights Act. We have the 14th Amendment. We have other areas of law that govern map redrawing. What I mean by you can only do so much is if you can imagine for yourselves sitting down to redraw a map. And Justice O'Connor has spoken about this quite eloquently in some of her opinions on these redistricting issues. I'll note that she's the only justice who has ever been a member of a legislature. So she understood this in a way that others did not. What she said was, this is self-limiting. At some point, you can only pack a district so much before you lose support in the next district. You can only ensure if you're a Republican map drawer and you're trying to develop as many Republican districts as you can, you only have so many voters to work with. The point there is that you can only draw a district in a certain way. These are still people, these are still voters in these locations, these geographic locations. One other point that I would like to address. We have always operated in a winner-take-all system. Whether you're a Republican, whether you're a Democrat, whether you're an independent. I represent a lot of defendants, so don't read anything into that. It has always been this system in our country that the winner takes all. There will always be a quote-unquote efficiency gap, and that is what experts are using right now to calculate where a partisan gerrymander goes too far. And the point being that if you want to change that system, there's a way to do that outside the courts so that you don't muddy up what is already fairly muddy for legislators this next go-round. I can speak more, but I wanted to address those points now.
Thanks. So let's roll back the tape for just a second to that fairly provocative and mathematically correct point that there's only so much you can do. But is that a reason not to do something about?
Well, I'm not so sure there's only so much you can do, because if you look at what has been done, there actually is an extensive amount of what can be done within the limitations of line drawing. I'm from California, and California is just notorious for what the Democrats did in order to maintain power and to take power, which is why finally there was a citizens movement to create an independent commission. But if you look at the lines that were drawn in North Carolina and elsewhere, I'm not so sure that there's only so many limits, because with the technology today that Wendy described, and then the movement that we're seeing in, at least, let's say in Missouri, where the legislature has been citing the citizenship question being added to the 2020 question as a motivation to amend their state constitution to allow redistricting by citizenship and not total population. There is much afoot here, and I'm not so sure that there are the kinds of limitations that Catherine suggested.
If I can, I'm not a redistricting expert, obviously, so if I can just bring this back to the census for a minute, because this is all really fascinating, but my mind keeps saying, when we draw the lines, we have census numbers. We're starting with the census, and that is the cornerstone of our democracy, and also whatever whatever litigators and line drawers are trying to accomplish. And so I think we have to realize that the numbers they're working with may be really flawed, right? They may be really inaccurate. And here's why. A successful census, I think, is one that counts all communities equally well. And the census is only as good as the public's willingness to participate. So we talked earlier about what could, really get in the way of that. But I think this is important because the census is not an equal opportunity enumeration. The count is never perfect, of course. It's been getting generally more accurate over time. But the census persistently misses disproportionate numbers of some population groups, while other groups are overcounted. And so people of color, especially men ages 18 to 49, young children, especially Black and Latino children, lower income households in rural and urban areas, but rural areas also, American Indian reservations, people living on Indian reservations, these people are all missed at disproportionately high rates. And so the overarching goal for the census is to eliminate what we call this differential undercount, because non-Hispanic whites and homeowners, which is a proxy for higher income, are overcounted. And so some areas are already getting an unfair share of political representation just because of the census numbers themselves, while others are not getting, their fair share. And so I think we really need to think about even the numbers that even, she's talking about in terms of, well, there's only so much we could do. We have the numbers, but the numbers themselves already systemically have, built-in inequality.
And is there anything to be done about that statistically, or does the Constitution's requirement of an actual enumeration require counting people one by one?
All right, so can I just go ahead. I was going to say, I'm going to say one thing, and then I want Arturo to talk about it. So this has not been decided constitutionally. The Supreme Court has not ruled on whether the Census Bureau can use statistical methods to what we call adjust the census counts. There have been numerous lawsuits, a lot of work for lawyers in this field, but that the Supreme Court has ruled that the Census Act, Title 13, does prohibit the use of statistical methods for the purpose of congressional apportionment. It is not ruled beyond that.
Right.
Go ahead.
And that was the point.
I'm sorry.
Yes, there's been a decision on the use of an actual enumeration without statistical adjustments for apportionment. But a state may decide to use a different data set for redistricting. Now, whether or not there'll be public confidence in a state deciding not to use the most recent decennial census is another matter, but a state could use other sources of data.
That's true. But I think we need to clarify. The Supreme Court actually has not ruled on the Constitution, the actual enumeration clause. They stopped because they could decide the case, as you know, on the Section 195 of Title 13. They have never reached, so interestingly, they have never reached the constitutional issue.
To tie these two questions together, we might think about the possibilities of these redistricting cases in the same way that we thought about the reapportionment cases that established the one person, one vote principle, like a principle of political equality that has become not just a foundational constitutional principle, but also essentially a moral principle. The reapportionment cases might, if they turn out in the way that some of us hope that they do, might establish a principle of either partisan neutrality or taking partisanship, making partisanship as a disfavored category for the type of fundamental democratic moves like redistricting, gerrymandering, et cetera, and maybe might even bleed over to other areas such as voter ID or census, right? Because one of the things that we worry about is the extent to which our political leaders are creating rules for democracy, not because they have legitimate reasons for them, right? We question their reasons. So is the census, are we adding a citizenship line because we really want to know or are we adding it because we're trying to gain some type of partisan advantage? And it's difficult in a democracy if you can't trust your political leaders, especially with the fundamental rules that they're doing something for a legitimate reason, or they're doing it for a particular partisan gain. And one of the hopes and possibilities of the redistricting cases, political gerrymandering cases, is perhaps they might give us a fundamental rule that is similar to the one person, one vote cases of establishing a rule of political equality that we now generally at least abide by or believe to be an important rule for decision making in at least one set of contexts.
Yeah, and I will add that that would provide some of the clarity that I think we all agree we need to have going into the 2021 redistricting cycle. I do want to sort of address again the connection between the census and the redistricting issues so that it's clear for folks. On the question of, only so much you can do, one of the issues that we've been sort of talking about is that anything that creates an undercount, and especially a differential undercount, will in turn affect redistricting, and it will shift power. It will affect apportionment, but it will also, in the redistricting level, shift power away from communities that have high levels of non-respondents, or in this case, largely communities with high levels of immigrants, to communities that have lower levels of that. And that is something you can do to impact insignificantly the redistricting allocation and lines. I want to sort of talk a little bit about the motive of why that citizenship question is being added and go back to this Evanwell question. But before, I just wanted to say that there is research out there about how much of an impact this is actually having. And so even though that there's only so much you can do in manipulating the lines to gain advantage, it's been having quite a significant impact. And I do want to sort of commend two recent studies by colleagues of mine, one of whom might be in this room, Michael Lee, looking at the impact of extreme gerrymandering on congressional redistricting, one that found that there was it accounted for a 16 to 17 seat advantage in the House of Representatives for Republicans in this past redistricting cycle. But another one which actually more closely shows really how it breaks the bonds between voters and the representatives that they elect, that actually looks at how much of an increase in vote share Democrats or Republicans would have to get in order to see more seats, to get an increase in seat share. And it's for a large swath of voting ranges, it's flat. You can get more and more and more votes before you gain any more seats. And net, it found that Democrats, in this very heated battle for Congress, would need to actually have a almost 11% increase, and this is assuming turnout levels don't dramatically change in the overall popular vote for Congress in order to see a change in controls. And that's like something we haven't seen for decades and decades. On the why this is happening, I think there's a lot of very overt signals that one of the main driving reasons for the citizenship question is to actually tee up that issue that was left in the Supreme Court's Evanwell decision back in 2016, which is whether or not it is permissible for states to use citizen population as their basis for redistricting. Currently, every state in the country draws district lines to equalize under the one person, one vote rule, total persons. And this is how it's been overwhelmingly been done since the nation's founding. There was an attempt in that Evanwell case to actually try to force the state of Texas to move to a citizen voting age population basis for redistricting, which would have really shifted political power dramatically in the state away from cities and more towards rural areas. That failed, but the court expressly left open the question as to whether or not it would be permissible for a state to do so if it wanted to do so. And we've seen a real aggressive push this year to try to move in that direction. There are several states that have legislation pending, that had legislation pending. They fortunately failed, but the Missouri legislation actually passed one house, and just timed out. I think there's a real reason to believe that this coming year we're going to see a real wave of laws like this that mirror the wave of vote suppression laws that we saw after the 2010 election. There is certainly mobilized efforts to push back against that, but I think that is something we're seeing. And we've seen efforts both by the Census, by the administration and by Congress also to push this issue. And I was recently informed that states have been asked whether or not they want to actually have data provided to them with the citizenship numbers for the purposes of redistricting. So it's really quite not on the below the surface, but on the surface that this is actually a primary goal of this effort.
I have 2 points, both on the topic of geography, and it touches on some of the things folks have been talking about. The first is that the term itself, gerrymander, is a geographical term. It has to do with a district that was drawn that looked like a salamander. I think we all have heard this by now. Now, in the courts, it has always been about the visual look of a district. How does it look? When we talk about a gerrymander, when we talk about a bad gerrymander, we're often talking about in courts a district that looks very ugly and bizarre is another term that the courts have used. Why that's important? I think it's about 39 out of 50 states now, and this is a constitutional society, have provisions in their constitutions requiring that districts be drawn so that they are compact. That constitutional provision is directed at this issue of gerrymanders. How do we keep these districts so they don't look like some strung out salamander, or I mean, we've all seen these districts drawn by both sides of the aisle, Republicans and Democrats, some crazy looking districts. How do we get those under control? Here's one way: you have constitutional provisions in state constitutions requiring that these districts be drawn so they are compact. Now, another issue on geography, and this is specific to Democrats. I'm not saying anything new, this is out there in the research. Democrats have a problem when it comes to redistricting if they're looking for some kind of equal proportion or proportional representation. And it's the fact that they live very closely to one another, and they live in urban areas. So that if you are a Democrat and you have the sole intent to draw a Democrat-strong map in a state, you are focused on spreading out that urban population of Democrats as much as you can. What's going to happen? You're going to end up drawing a lot of stringy districts that don't look that great, that do not pass compactness tests by courts.
And may violate the Voting Rights Act.
Correct, right. So you do have this issue, it's referred to as geographical gerrymandering or geographical redistricting, but this issue that Democrats have an issue with living so closely to one another that if you do apply traditional redistricting criteria, including that compactness requirement, you end up seeing districts that should be thrown out. There's an earmuff district in Chicago that looks that's very remarkable. I don't know if you've seen that one.
Luis Gutierrez's district.
You end up having districts that look bad, look uglier than if you were drawing districts that you were solely focused on drawing compact districts.
Or to put the point a different way, if you used only the most neutral redistricting criteria, Democrats would be at a disadvantage because they pack themselves into cities.
Yes, correct.
Guy, did you have a thought?
Just on the first point that Kate made, so I'm part of a group of folks at Duke who that includes mathematicians and geographers. And one of the fun things that they show, I'm the legal academic, they do all the math, is how you actually can do a lot of gerrymandering with beautiful districts or with ugly districts. And we could show you the various maps, and you wouldn't know, just by looking at them, what the distribution of political power looks like, right? Because there are ways in which political power can be distributed in terms of the line drawing that does not reflect the aesthetics of the district itself. So interestingly enough, we do have the ability to draw very beautiful, but what we then would say would end up being politically gerrymandered districts, and then to draw ones that are quite ugly, but could actually represent political representation quite well under even possibly pre-approved criteria if we were to agree on it beforehand. So it's not clear to me, quite frankly, at least on the current state of the knowledge, that that the aesthetics of the line drawing is directly proportional to the political gerrymandering itself.
And I wanted to add that there are multiple values that one tries to advance in redistricting, and, you know, compactness is one, but it is not actually the overriding one. And we have one person, one vote. We have values from the Voting Rights Act. We have keeping communities of interest together. So it's a range of different values
And
that people.
compactness is important.
Yes,
but-
it is. It is important. It is just not the only value. And so the concern here is that there's one value that we shouldn't be promoting, and that's sort of maximizing and locking in a partisan advantage and shutting out voters. But I will say that there are real positive reforms that we could do to get out of this conundrum, and there's been a lot of momentum, and that's another silver lining. There's been really mobilization in the states to reform the redistricting process so that this isn't a problem. Some of the legislation looks at setting criteria, like the way you said, so that constrains what legislatures can do and how they can draw maps. Others are actually changing who does the redistricting, taking it out of the Fox's house and putting it in the hands of independent redistricting commissions. And there are actually multiple ballot initiatives along those lines that are going to be, that voters in states like Michigan are going to be voting on this November. So that's another positive lining, certainly in states that have ballot initiative processes.
So one thing I feel like I'm hearing from several of you is that we want to drive partisanship in politics out of this process entirely. And I want to test that, because the Constitution does commit some redistricting to legislatures. And it oughtn't be terribly surprising that politicians act in their self-interests. So I don't know whether the point is to drive out partisanship entirely, or is the fallback position that there's some amount of partisanship that's too much. And if the second, how do we know that? Anyone?
I'll start with that. I mean, at the issue in the case, I mean, I think that there's a question that the reform efforts are trying to minimize partisanship, though they do have, the political parties have a say in the drawing of the lines, even in the independent redistricting processes. But the cases before the courts don't take the position that there should be no partisanship at all in the redistricting process. They are drawing a line to exclude what is extreme partisan gerrymandering, and to come up with standards where it goes so far that the skew is so dramatic that it locks in an advantage that is durable and lasts over an entire decade, and it is disproportionate, and it would and non-responsive to dramatic changes in voter preferences. And so that is the standard for where the cases argue courts should step in, and I think that makes a whole lot of sense.
So I used to work for a public university, and a lot of things were decided, especially with respect to the university, by the state legislature. But it was never the case that we would expect that the state legislature would say, oh, if you're a Democrat, you're going to get this type of treatment, and if you're a Republican, you're going to get this type of treatment. The fact that that certain things are decided by the political process or by political actors does not mean that we should expect certain levels and certain types of partisanship out of that process, right? And so the two things need not always go together. I think it's a fair question to ask, if we're going to permit certain types of partisanship, what are the levels? And that's a bedeviling one. I'm personally willing to toy with the idea that just because we have a political process for gerrymandering, that it has to result in any type of partisan advantage. I think when your political process selects you for disfavor simply because of your political identity, whether you're a Democrat or whether you're a Republican, that's a question that we ought to put some serious emphasis on, and to ask, do you have a good reason for doing so? And if there's a good reason, then perhaps we should yield. But if the only reason is simply to deprive you of political power, I think we're getting to the point in American society when we're starting to say, look, that is not a good enough justification, right? Selecting people for disfavor, whether they're African Americans or whether they're white or whether they're gay and lesbian, whether they're religious, right? So selecting people for disfavor simply because we're trying to deprive them of political power is not a sufficient reason. And I think these are the types, at least for me as an academic, the types of questions that are presented by these issues. And I'm willing to toy with the idea that says, look, what is the justification for partisanship here? And it's not clear to me that there's a very strong one, given the various ways in which representation can be organized.
And what triggers asking that question? Is it disproportionate results? Is it some legislative statement of intent? How do we know that the legislature has to justify? Because there's always going to be, I mean,
Yes.
many districts deprive voters of one political party of having an effective voice. Every single one of them needs to be justified?
In the North Carolina case, they said so we know very clearly that was what the North Carolina said, we would like to draw a district to achieve this partisan outcome, and that's what they did. I suspect if that becomes banned, that people will no longer say that out loud. But I think that this is the classic case of, ferreting out improper intent that courts grapple with in a whole range of areas, and that we were discussing before this panel. And there's a range of tools available to courts to do so. And there's statements, there's circumstantial evidence of intent, and generally it's a high bar of proof on people challenging the law to show the intent. But typically in a partisan gerrymandering context, the question wouldn't even come up if there isn't unilateral party control of a process. That would, the fact that the other party agreed to this would negate, or in most cases, evidence of intent to penalize that party. That would be one way of. So there's a range of considerations courts have in the race discrimination context and a whole range of contexts of law ferreting out improper intent, if we, which would be necessary in a partisan gerrymandering case.
Very quickly.
I'm sorry.
No.
I'll stand up and stand up for the idea that there is some value in having a legislature draw a map. It doesn't always have to be the legislature, but having someone who has local knowledge, having input in the map is important. I think we're losing sight of the fact that these are representatives who were elected to be sent somewhere else to represent interests of their home district, to participate in a legislative process, which when you look at all of these redistricting maps that were drawn back in 2010, you see public hearings, you see committee meetings, you see draft bills, you see consensus building. Now, is that always the example? Does that always happen?
Are you describing the modern legislative process?
Fair enough. I know. Fair enough. You can. But how are we electing anyone? How do we vote for anyone if we don't believe in that system? Why do we participate in this process at all if we don't believe that someone can go and
the fact is that today, nearly half of Latino eligible voters don't vote, in large part because they don't believe in the system, because of how the system has been rigged against Latino voters in this country.
So how do we fix that?
Well, I think some of the reforms that we're starting to see in California, and sorry to be, looking at the world through my California lens, but we do have an independent redistricting commission, and it I think fairly drew the line to the point that it actually gave the Democrats a supermajority in both houses for a while, they were drawn fairly, and they were having other reforms. We have a Secretary of State who now has moved to allow 16 and 17-year-olds to be registered to vote. We just had an election last, what week is this? No, it was this Tuesday. Yeah, 3 days ago. 3 days ago. And the initial turnout numbers is that it actually surpassed, the previous 3 elections that were at 36% for a primary. That's not bad, actually. You may have different opinions about 36%, but when you compare it to previous elections, at least you're moving in the right direction.
And I'm so sorry, but just one point. Arturo, what the point you made is, and you raised it earlier today, the Citizens Commission is exactly what I was talking about earlier, about there are solutions out there that are outside the courts that are driven by citizens that can be effective balms to some of these issues that we're discussing. So I just wanted to make that point.
Am I right that that's going to work in states that have ballot initiative processes, because legislatures are not going to voluntarily give up this power?
I doubt it.
Yeah, and but that's a little bit to the point of the question that you raise about do we trust legislatures? There are particular narrow sets of questions that relate to the self-interest of the legislature and their own maintenance of their own political power, where it is reasonable to have less trust in the purity of the motives of those legislators than on the other issues that they are sent somewhere else to talk about. And I think that the drawing their own lines and the rules under which they are elected is one of those questions where courts should rightfully be a little bit more probing.
So I always feel an obligation to bring all this back to the census, because that's what I do in life. But I agree. Before redistricting, there has to be a good census, right? But I agree that it is, vital that people have confidence in this process of redistricting, and similarly, people have to have confidence, in the census, and so that's my biggest worry. The risk that public confidence in the whole census process will drop significantly because we have the evidence that this administration is manipulating the census for political gain. That's what, Arturo kicked off our discussion with. And then there's fear that the administration will use the census to harm immigrants, even though there are strict protections, confidentiality protections in law, against sharing census data or using individual census data to harm any, to harm any person. So I think that, we're looking at a situation where confidence in the integrity of the numbers could plummet. And I think that could then bleed over to this process of, redistricting, where people say, well, you can't even draw the lines well because the numbers are so flawed.
Let me ask you a more general question, Terry Ann. Put aside this administration, put aside this set of questions. Should we have reason to be concerned that people don't want to participate in a government survey in an era when people are very scared about their privacy rights, have been burned on social media? Might they opt out of this, even aside from which administration or which set of questions?
Absolutely, and I'll start, but I want Arturo to jump in here. So you're right, even before the decision to add the citizenship, even before the request to have a citizenship question, we already were very concerned about a number of factors, what I've called an unprecedented confluence of factors that could create a perfect storm in 2020 that could thwart the census. There are segments of the population that just think the government has, limited authority, and they don't want to answer any questions beyond how many people are in the household. Those are conservative areas, very possibly. I'm concerned about the communities hit by the opioid crisis, where there's just disengagement from civic life, and also just fear of local law enforcement authorities. I'm worried generally about communities that have really strained relationships with local law enforcement. Law enforcement's the government. The Census Bureau's the government. It's all the government. So in places like Ferguson, Missouri, and the south side of Chicago, and other areas.
And let's not forget, this is supposed to be the first high-tech census. This is the first census in which the Census Bureau is hoping at least 42% of America's households answer their census by filling it out online. And there is a great deal of, I'm sure, suspicion people will have. What's going to happen with my data if I send it online? What are the Russians going to do with it?
Mm-hmm. Russia, we hope you're not listening.
Could I ask Terry Ann and Arturo a question? Would you agree that the data gathered by the citizenship question, if it is gathered, assuming it's gathered and it's useful and it's sufficient, right? The numbers are sufficient. Would you agree that it's important and useful data?
Well, first of all, I don't think that the data is going to be good.
You're fighting the premise of the question.
I have to.
No, but that is the whole fight.
There is one fundamental purpose for the census, and that is to obtain an accurate count of the population in order to reapportion seats in the U.S. House of Representatives. And we think that any effort that would undermine that one constitutional goal is really an end run around the Constitution. Okay, so that wasn't quite what you asked, but I say that because I don't think I think whether the data are useful, and you want to assume that the data are accurate, so I'm not going to quite give you that, but let's assume that I don't think that anything that gets in the way of an fair and accurate census overall is useful.
Yeah, I wanted to underscore that I don't think anybody disputes that if there was such a way of getting, complete and accurate and non-discriminatory citizenship data that people would find useful uses for it, more information's more valuable. The entire battle around this is that there is widespread belief by pretty much all experts and all census professionals that this is actually going to undermine the ability to not only get an accurate count, but even to get accurate citizenship information. It will not be even remotely correct. And so that's what the fight is about, not about whether or not that information
there is
in
a
the
reason-
abstract would be useful.
There is a reason why the Census Bureau removed the citizenship question from the decennial question after the 1950 census and put it on a survey, because it needed to be able to get more accurate citizenship data, and its scientists determined that using a survey method resulted in more accurate citizenship data than citizenship data collected on a decennial.
And that was the case, by the way, for a lot of data collected in the census. So there used to be one form, and it asked a lot of questions beyond what was needed for apportionment and redistricting. As Arturo correctly pointed out, as survey methodology became more robust around that time, survey methodologists determined that asking a lot of questions only from a representative sample of the population actually could produce more accurate data. And if you don't really need it from every household, in other words, at the block level, then why burden the census itself with all of these questions? And by the way, then Congress, and this is when I was in Congress, particularly going into the 1990 census, said, this short form is too long, and we really have to start, moving a lot of this information just to collect it from a survey, as long as the data are sufficiently reliable and accurate, and the Census Bureau the experts have determined that they are. So I'm not so sure, even though I agree, Wendy, that it's good to have a lot, more data if it's accurate, I'm not so sure we really need citizenship data at the block level from every household, unless, and this is what we heard at this hearing this morning from Chairman Steve King and Subcommittee Member Louis Gohmert and others, that we really need to know exactly how many citizens there are, in every little block in the country. Do we? For what purpose? So I'm not sure that we need to.
Well, the even well is the purpose.
Well, that's the undercurrent. You're right.
So I confess I haven't followed these litigations, but a bunch of litigations have been filed to challenge the census question. I don't even know what the legal theories are. Is anyone in a position to bring us up to speed on?
Yeah, go for it.
Sure. There's a range of legal theories, including that it would interfere with the fundamental constitutional purpose of getting a complete and accurate census for the purpose of apportionment. There are claims that are anti-discrimination claims under the Equal Protection Clause. There are claims under the Census Act, that it violates the Census Act, and there are also claims via the Administrative Procedure Act. So they didn't follow, both in terms of the process by which, challenging the process by which the question was put on or announced, and or lack thereof, and its insufficiency.
So the chances of some judge in San Francisco or Brooklyn or Boston issuing a nationwide injunction reasonably high?
Yeah, so I think, you're right. We have a couple of options here. I'll just say quickly, based on the long series of cases that ended up deciding that the Commerce Department or the Census Bureau had not violated any provisions of law to reject the possibility of statistically adjusting the census to eliminate or correct for these undercounts and overcounts. So I think that some of these courts could just decide this on that, maybe higher up courts, on the Administrative Procedure Act. This is what happened with those statistical adjustment cases, to say, well, they have the discretion. The secretary did not make an arbitrary and capricious decision. But I think you're right. I think some of these courts we're hoping could say, wait a minute, this violates a constitutional standard of the accuracy of the census. I am praying and hoping that we can get some court to address that issue, because that has not been addressed. What does the Constitution require in terms of a level of accuracy? What is the standard for a census that is not good enough constitutionally to serve as the basis for apportionment? That's what I'm hoping we'll get from some court.
I want to just say, though, that the arguments shouldn't be made only in court. I mean, I think that the courts are important here. I think that it's not the only way to reverse this citizenship question. There are going to be there's a notice and comment rulemaking process that started that should have preceded any of the addition of the question. I think that to the extent that the public, the business community, cities, the vast array of the American populace that actually relies on citizenship data for all of the things that census data for all of the things that they do and all of their decision making ought to step up now, because this is really going to undermine that really critical underpinning of not just our democracy but a lot of our society. So there's a window of time where the courts aren't the only venue to make this change.
And we should say, I mean, conceivably, Congress, not this Congress, but maybe the Congress after next November.
That same ideal legislature we were hearing about before.
Also, of course, there has been already, amendments to remove the citizenship question. I just want to remind everybody of one thing. The Alabama lawsuit,
yes,
right, that was filed, the other side of this issue and this happened before the 1990 census, to exclude undocumented residents from the state population totals derived from the census that are used to apportion the U.S. House of Representatives, would then require the Census Bureau to add another question to determine legal status somehow. Are you an asylee? Are you a refugee? Are you under temporary protected status? Look at the DACA recipients. They don't know what their status is. And then, obviously, what they're trying to get at is, can we get very precise numbers of how many people are undocumented? That'll blow up the whole census. I mean, that would just be a grenade. But that's what that would, if that lawsuit were successful, that's what.
I should say it is I think a fairly frivolous lawsuit under existing law. That said, the current Department of Justice is who's going to defend the against that lawsuit. So it is not damage free, but I think that
and just to make it really interesting, though, there's some concern that this Department of Justice might not vigorously defend against that Alabama lawsuit. There's a lot of interesting things to watch.
So I have a bunch of other topics and questions, but I look around the room, I see so much expertise. I know you guys have questions too. So please, if you wouldn't mind using the microphone, I'd love to get your thoughts.
Hi, I have a question. A lot of this discussion around redistricting and political power has been Democrats versus Republicans, but I think the elephant in the room is race, right? Because to the extent that minority communities have become aligned with particular parties, and to the extent that you're talking about apportioning power among the states that have different demographics, how should we look at that lens, particularly since this redistricting in 2021 is likely not to have the full protection of the Voting Rights Act, because Section 5 has still not been fixed? So do you look at it differently when you think to yourself, gee, all of these voter ID laws and redistricting things and suppressing the count of people who are minorities. Does that change how you view how this should be looked at in terms of the health of our democracy?
Well, I think, I looked at all my colleagues because I thought they ought to answer this, so I'll just start quickly. I mean, that goes back to the question, Karen, of are we ready to accept the demographic change that is occurring and will influence the distribution of political representation in Congress at the state level, at the local level, and clearly there are people who are not willing to concede that this country is changing markedly demographically. I suspect Arturo wants to
one of
jump in.
the changes that the Census Bureau is not being allowed to proceed with is to redesign the way it asks each of us to report or how we self-identify our race and our ethnicity or Hispanic origin. And in my opinion, one of the reasons why the Bureau was not allowed to do that is because it was suggested that it would result in a smaller white population in the country than what would be collected through the current two-question method as opposed to a combined question, which the Census Bureau, after years of research, had recommended, and that research was just dismissed.
Well, you're clearly right that race is interrelated. All right, there's no doubt about that. It's also the case that it has always been so. One person, one vote cases, the reapportionment cases were those issues were not unrelated to political power with respect to racial power. And we can go back as far as the 3/5 compromise. Right, so the question of political power and its distribution in American politics, American constitutional law, has always been there and tied to questions of racial equality. And so maybe they're made a bit more exacerbated by the fact that we're starting to have parties that are racially identifiable much more clearly than perhaps before, and also that the legal rules are a bit murky and unclear, both as to what will happen when the court decides the political gerrymandering cases, which are related to whether those claims are going to be gerrymandering or racial claims, but also the uncertainty of the future of the Voting Rights Act. So yes, no more Section 4-5 protection, but how much pressure is going to be put on Section 2 and how long will that last? Right, so there are a series of perilous issues going into the future with a lot at stake and a context in which we understand better, I think, how political power is going to be affected by the relationship between race and politics.
Ellen?
I just wanted to add one minor addition to that, is that I think that it underscores the importance of addressing both sets of issues, the fact that they are intertwined so that one can no longer rely on partisanship as a way of trying to evade any kind of accountability for a race discrimination. So, I mean, that has happened not just in the redistricting context, but also in the voting context. I'm not disenfranchising African Americans, I'm disenfranchising Democrats. So I think that actually addressing them both, I think will at least tighten up protections, not enough to fully address the loss of the Voting Rights Act, of course. I see someone in line who could actually provide a very excellent answer to this question as well.
Yes, Alan.
So I want to answer your question, Adam, how much is too much? Justice Kagan, during the oral argument in the Maryland case, said this is an easy case. They had 10,000 people that they had to move to fix up one man, one vote, and they moved 400,000 Democrats and 300,000 Republicans. She said this is an easy case, and we would have seen this in the race cases, and we would have had no trouble saying on a district-by-district basis this is no good. That doesn't solve the statewide problem, but it does it there. And to pick up Wendy's point, as you remember from her opinion in the Virginia case, she struggled mightily. The defense was, oh, no, we didn't move all these people because we're black. We moved them because they were Democrats. The fact that almost all the blacks were Democrats and all of that didn't seem to be a good defense, and she said she wouldn't let that happen. So she has that opportunity to get that, and that would deal with the problem of the defense being, oh, no, it's all about politics if politics are not enough. Last thing I want to say to Catherine, there are limits as to what you can do with districts now. Part of the reason is that in the late 60s, Congress passed a statute forbidding multi-member districts for congressional districting. And the reason they did that was because in many places in the South, there were multi-member districts, and so places that had a third of the multi-member districts all being blacks, they could keep any blacks from being elected by having the multi-member districts with the winner-take-all. So that there are legislative solutions for that, but somebody has to confront that issue directly, and that raises a host of other problems.
Hello, Pam.
Hi. So this has been just an amazingly interesting panel. I want to pick up on something Terry said and make two observations about it, which is she said, in 1920 we didn't have reapportionment, and it wasn't just because the country had become urban, it was also because that was the year in which the census revealed the highest proportion of non-native born people in the United States, and that proportion is quite similar to what we have today. And so for those of you who are interested, I just published an article in the William and Mary Law Review that's about the 1920 census and the decision not to redistrict then. So I hope somebody will read the article. But the question I have for the panel about this comes out of what happened after 1920, which is before that, Congress used to just decide every 10 years, it would just allocate the seats. And so there would be a bill that would say, Texas gets 32 seats and New York gets 14 seats. And in 1941, because they couldn't agree about this, in 1929 and then again in 1941, they passed permanent apportionment acts, which set a formula. And the Secretary of the Census, as Secretary of Commerce, is just supposed to tell the president, who then certifies, this is how many seats each state gets. And what I want to ask you about is, are you concerned, especially after the most recent thing that happened in the Judiciary Committee, that there will be pressure on the Permanent Act for a formula that will advantage whoever's picking the formula? Because there are like 15 different formulas out there for deciding how to allocate the 435 seats, which, by the way, itself isn't fixed. That is, you could increase the number of seats or you could decrease it. And so I just wonder, are any of you concerned about or hearing anything about possible manipulation, not just of the seats, but how they're allocated and how many there are?
Okay, so this is really interesting. Thank you for all of that. They're all very correct. And just very quickly, so of course we have what the current formula is, the method of equal proportions. But I'll just say this. I think, no, we have not heard anyone talking about that at this point. Let me just say that. I think this Congress, and I'm a creature of Congress, I love Congress, is so dysfunctional at this point that I can't imagine them, arguing and having a rigorous debate about these allocation formulas, which about 5 mathematicians in the whole country know how it works. I can explain the current one in layman's terms. But seriously, this stuff is so complicated, I just don't really see them doing that. But it's a very interesting point and well taken. And by the way, this is called an automatic apportionment formula. She's absolutely correct that this was an effort to say we're just going to have a formula that automatically, it comes out one way. You feed the numbers in, the apportionment comes out, and it gets reported to Congress, but the law does provide within 15 days of Congress receiving those, the apportionment and the state population totals if Congress has to be in session, Congress can reject the apportionment, and that's what we're talking about now in terms of what could happen.
I did read Pam's article, and you all should too.
And I will. Next thing I'm going to read.
But just to very, very quickly, I think when we're in a world in which the stakes everyone feels that the stakes are so high, right, and there's a sense of asymmetry in terms of what one side is willing to do, and that things that were once unthinkable are now thinkable for partisan challenge. And I think that's the point where that we're worried about, the limits to partisanship for political gain, because then everything becomes up for grabs as long as you can get away with it in the political process. And in the current world in which we are all partisans, right, so fixed partisan identity, we're increasing a framework in which People now are starting to think, yeah, I don't care if my child marries a person of a different race, right? So those numbers are fairly good. But we're starting to increase the world. If they marry someone from a different party, forget about it, right? Because we're so fixed in our partisan identities. So tell me, if you want to know what I believe, then tell me which person of the other party said it. Then I will tell you what I in fact believe. And so if partisanship becomes fixed in that way, and the stakes are perceived to be so very high, then everything is on the table, including the fundamental rules that enable us to get structural advantage.
And I want to just put an emphasis on that. I think that is the erosion we've seen across a range of areas in the democracy space, in redistricting, in voting, in North Carolina, in everything, of the kind of removal of these guardrails or any norms that prevented everything from being up for grabs for partisan advantage and from being manipulated. And I think that that's what our job is, to try to guard against and to rebolster those norms.
Yes, sir.
So, thanks for this great discussion. There's been several references to the set of efforts on the right that are actually connected to one another to say, really, political power should go just to voters, just to citizens, just to voters, is what the Evenwell case, much discussed, was about. In a different way, it's what the Alabama litigation and the Missouri bill and various different efforts are all about, whether we're manipulating the census or just what we do after the census. They have a narrative which is political power should go to the people who vote, the representatives should only represent the voters. And as Wendy helpfully pointed out, one thing one can say on the other side is, well, that's certainly new. For all of American history, we have had an idea that the representatives represent everybody, including immigrants who arrived yesterday and can't vote, and including children. Exactly. So, but my question for you is one of, what I haven't heard is a sort of higher level argument or message that I think it might be helpful for this room to hear as to why that's actually either good or what the Constitution, requires that we do. That is, why is it important for the representatives to represent children and people who are non-voting, not eligible to vote for various reasons? What are the stakes there, and how would you articulate them, or hope that some of the ACS members in this room could articulate those stakes? Yeah, this could be Wendy, Arturo, Guy, many of you.
Joey, I'd love to hear what you have to say.
I think that this is a fundamental value that is the job of everyone in this room, to make the case that while political power and voting power is allocated to eligible voters, representation is actually supposed to include everyone, and that is a founding principle of this republic. And how to make that case morally salient to everybody. And it includes not just non-citizens, not just children, people who didn't vote for you as well. I think that, this is a fundamental premise of representative democracy that's being sort of trying to be reshaped and readjusted, and we need to actually make that political case for it. Taxation and representation, and I think it's a big job for all of us. I will add that the efforts right now, the legislative efforts that we've seen, are not seeking to limit the benefits of this representation to only voters. It's to voters plus children. Like they're only excluding non-citizens, only one group of non-voters, which I think undermines the moral and principled case for it, but it does not make our job any less difficult to make that case for the system that we have.
And I would just add, I love this, and now I can see we need an op-ed, sort of in the New York Times right away.
That solves everything.
Yeah. But I will say, I completely agree that is a question of the fundamental values of this country. Who is going to speak for those who cannot speak for themselves? Yeah. So I think that's what it comes down to, and we are at a point in this country where there is just a battle of values, and so I think this issue falls under that umbrella, so I love that. Yep, Karen, we're on it with op-ed, okay?
Very quickly, it's not going to answer your question, but I think it's a very complicated question, right? Because it forces at least those who would make the other side to rely on some really tough history, right? So the worry that we've always said, well, women don't need the right to vote because they're virtually represented through. Black people don't need the right to vote because they're virtually represented through, and so that that makes trying to make an argument on representation much more broadly a really difficult one. It may also be that part of where the argument needs to be joined is it's not just that citizens are being elevated. It's a certain type, right? It's my citizen, just not your citizen. And there, I think that ground should not be ceded either. But you present a challenge, and I think it's one that needs more thought. But I think it's complicated by the history of our country and the ways that we've apportioned political power legally and constitutionally.
And I just have to say, so Congressman Raskin, right, who's a lawyer, said at the subcommittee this morning, and then he submitted an old law review article for the record, but he reminded everybody that there was a point in our, right, exactly, oh, he was wonderful, he was terrific, that he reminded everybody that there was a time when a number of states, I think many states, allowed non-citizens to vote, right? So there's a long history, as you said.
This is an assignment for everyone in the room.
I was going to say, great, fascinating issues.
So I fear I'm going to disappoint some of the people who've been waiting patiently online, and we're going to have to wrap up in just a couple minutes, but let's see if we can get one more question in.
All right, so this is a question Terry will like because it's on the census. So I understand the Supreme Court basically said you can't use any kind of adjusted census for the apportionment, but I assume that you can use adjustments to the census numbers for other purposes. And I'm just wondering, given that, as our population grows and we may expect that an adjusted census might be more accurate, your kind of thoughts on, number one, I don't know whether, in fact, there's any plans for this commerce and this census to actually use any adjustment, and whether that would make sense, and if, how we should go forward doing that.
Okay, so that's a good question, but in a nutshell, and I think Arturo, mentioned this earlier, as you said, that the Supreme Court really left open the case because they only decided that case under a very narrow provision, Section 195 of the Census Act, Title 13, which says that they may not use sampling for apportionment purpose. So everything else is left open, but this is the bottom line. Republicans now believe that using statistical sampling to improve the accuracy of the census count is an anathema to them. I mean, they are diametrically opposed to it. They have come after people like me and others, very viciously, but there will be no chance of a statistical adjustment of this census in any way, shape, or form, because it's just the party in power right now would never even allow the Census Bureau to start researching that possibility again.
I'm terribly sorry. This is such a rich topic, and we can go for a long time, but they told me I have to wrap this up. There's lunch with Justice Sotomayor coming up immediately after this session. Please join me in thanking this terrific panel.